So he walked through that courtroom door, and I knew before he reached the podium, before he said a single word, that something was deeply wrong. Not wrong in the way that people who appear before me are usually wrong. Not a traffic citation, not a parking fine. Wrong in a way that made my chest tighten behind this robe I have worn for decades. He was wearing a pressed shirt, ironed by his own hand, I would later learn, because there was no one else to do it for him. His shoulders were squared. His chin was level. He walked the way men walk when they have been trained to hold themselves upright even when the world is collapsing beneath their boots. He stood at that podium and he looked at me and I looked at him, and in 30+ years on this bench I have learned that the eyes tell you more than any document ever will. His eyes told me everything. And if you stay with me through this story, every word of it, you will understand exactly why I did what I did next. You will understand why I stopped the entire hearing, why I told my clerk to hold every case on the docket, why I came around from behind that bench, something I almost never do, and stood next to this man in open court. I am going to tell you what happened that morning. All of it. And I promise you, before this story is over, you are going to feel something you will not be able to name easily. You are going to feel it in your chest. Because justice, real justice, is not a cold thing. It is not paperwork and procedure. It is not a gavel and a fine. Real justice is what happens when a person who has been carrying a weight they should never have been asked to carry finally sets it down. His name was Raymond Kowalski. He was 67 years old. He came to my courtroom on a Tuesday morning in October, and he came alone. Let me tell you why that detail matters. Let me tell you why alone should have been impossible. Raymond Kowalski served 2 tours in Vietnam. He came home in 1972 with a Purple Heart, a Bronze Star with Valor device, and shrapnel fragments that the VA doctors told him they could not safely remove from the area near his lower spine. He came home to a country that did not know how to look at men like him yet. He built a quiet life in Providence. He worked 22 years at the same machine shop. He married a woman named Dorothy, who passed from cancer in 2019. He had 1 son, estranged, living somewhere in Arizona, unreachable in the ways that matter. And he had a small house on the east side, a house he had paid off, a house that was his. That is the word I want you to hold in your mind right now, his. Because by the time Raymond Kowalski walked into my courtroom that Tuesday morning, that house was being taken from him. And the people taking it knew exactly what they were doing. The citation before me when his case was called, before I knew any of what I just told you, was a municipal housing code violation. On its face, it looked routine. The city had issued a notice of violation against Raymond's property: deteriorating exterior structure, compromised roofing, failure to remediate after notification. The kind of case I see dozens of times a year. The kind of case that moves through this courtroom quickly. The kind of case I was prepared to resolve in under 3 minutes. Then I asked him a question I always ask, because I have learned painfully over years that the file and the truth are not always the same document. I said, "Sir, before we proceed, I want you to tell me, in your own words, what happened." And he looked at me, and he nodded slowly, as if no one in a long time had asked him to speak first. He said, "Your Honor, I hired a contractor." That was the beginning. And I want you to understand, at that moment I had no idea how far this was going to go. I had no idea what Raymond was about to show me. I had no idea that the name of that contractor was going to appear 3 more times before the morning was over, each time worse than the last. He reached into a manila envelope, worn at the corners, handled many times, and he placed a document on the podium, a contract. I asked my clerk to bring it to me. I read it. I am a lawyer. I have been reading contracts for 40 years. I read that contract and I stopped. I reread the relevant clause, and then I set it down very carefully, the way you set something down when you do not want to show on your face the thing you are feeling. That clause, buried on page 4 in a font size that I would have required a magnifying glass to read comfortably, stated that in the event of any municipal code violation related to work performed, all associated fines, penalties, and legal fees were to be borne exclusively by the homeowner, not the contractor, the homeowner, Raymond Kowalski, the man who had paid this company $11,000 to repair his roof after storm damage, the man who had trusted them with his house. Are you beginning to understand? The contractor had performed the work. The contractor had done it incorrectly. The city had inspected and issued violations. And now Raymond, a 67-year-old widowed veteran on a fixed income, was standing in my courtroom alone to answer for work he had not performed, errors he had not made, a roof he had paid someone else to fix. and which that someone else had left in a state that now threatened the structural integrity of his only home. He told me the contractor's name. I will not use it here. I will tell you why in a moment, but I will tell you that when he said it, something shifted in the room, because one of my clerks glanced up, and that glance told me that this name had been in this courtroom before. I asked my clerk to pull the records. Now, while I am waiting for those records, I want to tell you something else, because the story does not pause just because I am waiting. Raymond, standing at that podium, reached back into his manila envelope. He produced a second document, a letter. He slid it across the top of the podium with 2 fingers, the way a man handles something that has already cost him sleep. He said, "Your Honor, after the violation was issued, I contacted the contractor to ask them to come back and correct the work. They sent me this." It was a letter from the contractor's attorney, a cease-and-desist letter, threatening Raymond Kowalski, a decorated combat veteran, a man who had done nothing wrong, with a lawsuit for defamation. Because he had written a review online, because he had told the truth about what they had done to his house. I want to be precise about what I felt at that moment, because precision matters in this room and in this story. It was not surprise. I have been on this bench long enough that very little surprises me. What I felt was a cold, settled, absolute clarity. The kind of clarity I feel when something that has been disguised as complexity reveals itself to be simple. This was not complicated. This was predation. Deliberate, calculated, and targeted at someone who had every reason to believe the system would not protect him. And here is what I need you to understand. He almost did not come. He told me this himself. He said, "Judge, I almost didn't show up today. I figured nobody was going to listen. I figured I'd just pay whatever they said and figure out the rest later." That sentence stopped me cold. He almost did not come. He almost accepted an injustice rather than believe that this room, my room, would treat him as something other than a number on a docket. I want every single person watching this to feel the weight of that. He almost did not come, because if he had not come, he would have paid a fine he did not owe. He would have borne the legal cost of someone else's fraud. He would have gone home to a damaged roof and an attorney's threatening letter, and no voice, no recourse, no one sitting across from him and saying, "I see what happened here and it is going to stop." But he came, and I am going to tell you what I did about it. My clerk returned with the records, and I need you to stay with me here, because this is the part where the story becomes something else entirely, something larger, something that made me angrier than I had been in years. That contractor's name appeared in my court's records 6 times in the preceding 18 months. 6 times. 5 of those 6 cases involved elderly homeowners. 4 of those 5 involved properties in lower-income neighborhoods. And in every single case, the pattern was identical. A contract with buried liability language, substandard work, a municipal violation, and the homeowner left standing exactly where Raymond was standing, in front of a judge, alone, holding documents that proved everything and knowing nothing about how to use them. 6 cases, 18 months, the same predator. Moving through this city, through these neighborhoods, through these homes, picking people who looked like they would not fight back. I took off my glasses. I do this sometimes when I need a moment. Not because I cannot see, because I need to be sure of what I am about to say before I say it in open court. Then I did something I almost never do. I said, "This hearing is suspended." The courtroom went quiet, not the ordinary quiet of procedure, the particular quiet that falls when something unexpected has happened and everyone in the room knows they are watching something that does not happen every day. I said, "Mr. Kowalski, I want you to step to the side for just a moment. I need to make some inquiries." I asked my clerk to place a call to the city's Housing Enforcement Division. I asked for the supervising inspector on duty. I asked that person on the record in open court whether any of the violations issued to properties connected to this contractor had been flagged for investigative review. The answer was number 6 cases, same contractor, same pattern, not one flag. I asked why. The answer I received was bureaucratic. It was about jurisdictions and reporting thresholds and review timelines. And I understood technically the procedural explanation. But I want to be clear about something. Technical explanations do not justify moral fa ilures. A system that processes injustice efficiently is not a just system. It is a sophisticated machine for delivering the same outcome to the same people over and over and calling it procedure. I said that on the record, in open court, now, and I want you to hold on because this is the moment I promised you at the beginning. I asked Raymond Kowalski to return to the podium, and I asked him one more question. I said, Mr. Kowalski, before I rule on this citation, I want to ask you something personal, and you are not obligated to answer. He nodded. I said, how long have you been carrying this alone? He was quiet for a moment. A long moment. And then he said, since Dorothy died. Dorothy, his wife, dead since 2019. And since then, since the day that Anchor left, Raymond Kowalski had been navigating everything by himself. The house, the finances, the storm damage, the contractor, the violation, the legal threats, the sleepless nights trying to understand documents that were deliberately designed to be incomprehensible. He had been alone through all of it. I am going to tell you, and I will not apologize for saying this directly, that in 30 years on this bench, that answer broke something in me. Not my composure, not my authority. Something smaller and more important. It broke the professional distance I sometimes need to do this job. Because I know what alone looks like after the weight gets heavy enough. I have seen it in this courtroom hundreds of times. And every single time I feel the same thing. This should not be. This should never be. Raymond Kowalski spent 2 years in jungles that most of the people who sent him there could not have found on a map. He came home carrying something that doesn't come out of the body with a surgical instrument. He built a quiet, honest life. He loved his wife. He paid his mortgage. He played by every rule this country set out. And when a predator came for his house with a fraudulent contract and a lawyer's letter designed to silence him, the system that was supposed to protect him processed him like a file number. I dismissed the citation. Completely. With prejudice. Not conditionally. Completely. The fine was 0. The violation expunged from his property record. I put that on the record with language precise enough that no one could revisit it. But I was not finished. I directed my clerk to compile a full case summary of all 6 contractor-related violations and forward that package to 3 entities simultaneously. The Rhode Island Attorney General's Office, the City's Office of Consumer Protection, and the State Contractor Licensing Board, with a cover letter bearing my signature and a request for expedited review. I want to be clear about something. I cannot prosecute. I cannot subpoena. I cannot compel a criminal investigation from this bench. I know the limits of my jurisdiction as well as I know the back of my own hand. But I can make noise. I can create a record. I can put a name in front of the people whose job it is to do what I cannot, and I can make it difficult, politically, professionally, morally, for them to look away. And I did exactly that. I also said something else on the record that I want to repeat here, because I mean it just as much now as I meant it then, standing in that courtroom with Raymond Kowalski beside the podium and a gallery full of people who had gone very still. I said the law is not a tool for the strong to use against the vulnerable. When it becomes that, it is no longer the law. It is something much uglier, dressed in the law's clothing. And it is the duty of every person in this system, every clerk, every inspector, every attorney, every officer, to refuse to be part of that machine, whether by action or by silence. I want to talk about what happened after, because this story does not end with the gavel. When Raymond turned to leave, I asked him to wait. I had asked my staff, while I was making those calls, to do something else. I had asked them to contact the Veterans Services liaison assigned to this courthouse. Her name is Sandra, and she has worked in this building for 11 years, and she is one of the finest people I have ever encountered in any professional capacity. Sandra was in that courtroom within 4 minutes. She sat down with Raymond at the table to my left, the one the attorneys use, and she began, quietly and efficiently, going through his situation. Not just the housing violation. All of it. The VA benefits he was potentially not receiving. The legal aid resources available to him. The veteran-specific housing assistance programs that he had not known existed because nobody had ever told him they existed. 4 minutes? That is how long it took for Raymond Kowalski to go from standing alone in front of a judge to sitting beside someone whose entire professional purpose was to help men and women exactly like him. 4 minutes that should have happened years ago. Here is what I need to say about that, and I am going to say it plainly. The tragedy in this story is not the contractor. The contractor is a criminal, and criminals exist in every era and every city. The contractor will face consequences. I made sure of that, and that chapter will close. The tragedy is the gap, the space between what Raymond needed and what was available to him. A space filled not with malice, but with indifference. The indifference of a system that assumes people know where to look. That assumes vulnerability will announce itself. That waits to be found instead of going to find. Raymond did not know about Sandra. Sandra was 40 feet from his courtroom every single Tuesday. For years, and no one had ever connected them. No one had ever said, "Sir, before you go, is there anything else you are carrying that you should not be carrying alone?" I started saying that. From that day forward, I started saying that. Not just to veterans, to every person who stands at that podium and carries something in their eyes that has nothing to do with the citation in the file. It is a small thing. It takes 8 seconds. But I have seen what 8 seconds can do when they are the first 8 seconds in which someone has felt in a long time that they are worth being asked. Now, the contractor. I told you I would come back to this. I told you the name would appear again. And I promised you I would explain why I did not say it on camera. 2 months after that Tuesday morning in October, the Rhode Island Attorney General's office opened a formal investigation into that company's business practices. The Contractor Licensing Board suspended their operating license pending review. 3 of the 6 homeowners I had flagged, all elderly, all on fixed incomes, all carrying violations they should never have borne, received direct outreach from legal aid attorneys who had been briefed by my office's referral. The contractor's attorney, the one who had sent Raymond that cease-and-desist letter, the letter designed to silence a 72-pound punchbag of a man who had done nothing but tell the truth. That attorney withdrew the threat within 10 days of my referral letters going out. 10 days. They had sent that letter betting that Raymond Kowalski would fold, that he would see a lawyer's letterhead and go quiet, that a man his age in his situation, alone, without Dorothy, without his son, without anyone in his corner, would simply absorb the blow and stop making noise. They were wrong about Raymond, and they were catastrophically wrong about what would happen when Raymond walked through my door. Because Raymond did not just save himself that Tuesday morning. He saved 5 other people who didn't yet know they needed saving. He saved them by coming, by bringing that worn manila envelope, by standing at that podium with level shoulders and clear eyes and trusting, against every reason he had not to trust, that someone in this system would listen. I have thought about that many times since. I have thought about the version of that morning in which Raymond stayed home, in which he paid the fine, in which he tucked the contractor's letter into a drawer and decided, as so many people decide, that the fight was not worth it, that the system had already told him what it thought of him. That one man alone cannot change the outcome that has already been written. I have thought about the 6 families in that version of events who never get a phone call, who never get Sandra, who keep paying, who keep absorbing, who keep being processed. And I think about this. If Raymond almost did not come, there are hundreds of Raymonds who did not come, who are not coming, who are sitting right now in apartments and houses and rooms carrying things they should not be carrying because somewhere along the way they decided the door was not open for them. I want to say something to those people directly. Because if you are watching this, I want you to hear it from someone who has sat behind a bench for a very long time and watched what happens when people give up versus what happens when they do not. The door is open, not because the system is perfect. It is not. I know it better than anyone. It is slow and it is bureaucratic and it is riddled with gaps that should not exist and indifferences that should not be permitted. But the door is open, and behind the door are people, Sandra and legal aid attorneys, and clerks who go home at night troubled by the cases that troubled them, and yes, sometimes judges, who are waiting to hear what you are carrying, who will listen, who have the ability within the limits of their authority and the reach of their voice to do something. Come in. Bring your documents. Bring your worn envelope. Come alone if you have to. You will not leave the same way you entered. That is a promise, not an abstraction. A promise made by a man who has watched it happen. Watched the weight shift. Watched the shoulders drop a fraction of an inch. Watched the eyes change more times than he can count. Raymond Kowalski walked out of my courtroom that Tuesday with a dismissed citation, a VA services appointment the following Thursday, and a legal aid referral thaw. T would eventually recover a portion of his contract fees through a civil claim filed on his behalf. He walked out with something else too, something I saw in his posture that was not there when he walked in. He walked out like a man who had been heard, not agreed with, not pitied, not handed something as charity. Heard. Treated as someone whose account of events was credible, whose documentation was taken seriously, whose service, his years, his medals, his shrapnel, his Dorothy, his quiet, honest life built on a promise this country made to him when he raised his hand, counted for something in a room where these things are supposed to count. I told him before he left, and I am not a sentimental man, I want to be clear about that. I did not build a career in this room by being sentimental. I told him, Mr. Kowalski, Thank you for your service, and thank you for trusting this court. He looked at me for a moment. Then he extended his hand. I took it. In 30 years on this bench, I can count on one hand the number of times I have shaken the hand of someone who appeared before me in a case. Not because the rule prohibits it, because there are not many moments when it is the right thing. That morning it was the right thing. And I knew it the same way I know most of the things I am certain about in this room. Not from a statute or a precedent, but from somewhere below the robe where the rules do not reach. He left. The case was closed. The file went into the archive. But I am still telling this story. I am telling it because the story is not the file. The file is closed. The story belongs to everyone who needs to hear it. Here is what I want you to take away. Not the legal outcome. The legal outcome is important, but it is not the lesson. The lesson is smaller and harder and more important than any ruling I have ever entered. The lesson is that Raymond Kowalski almost did not come. And everything, the contractor investigation, the 5 families, the cease-and-desist withdrawal, Sandra, the Thursday VA appointment, the civil recovery, everything hinged on that one decision. The decision to walk through the door, press shirt, level chin, alone, against all the reasons not to. I have seen courage in this courtroom. I have seen people stand up and tell hard truths about themselves and about others. I have seen people take responsibility when it would have been easier to run. But I am not certain I have ever seen a quieter, more durable, more consequential act of courage than an old soldier deciding, against his better judgment, to trust the room one more time. He was right to trust it. And it is my job, and the job of everyone who wears a robe or a badge or a clerk's lanyard in a building like this, to make sure that trust is never misplaced. I have been doing this work for a long time, long enough to have seen the worst of what people do to each other when the law looks the other way. Long enough to have seen what happens when the system treats the vulnerable as a revenue stream instead of a responsibility. Long enough to know that the measure of any court is not the volume of cases it closes, but the quality of justice it delivers to the person standing at the podium who has no one else to call. Raymond Kowalski had no one else to call, and that Tuesday morning in October, he did not need anyone else. He had the law, and on that morning in that room, the law showed up for him. That is what this bench is for. That is what this robe means. That is why I put it on every morning and walk into this room and look the next person in the eyes before I look at their file. Because behind every file is a Raymond. Behind every citation number is a Dorothy who is gone, and a son who doesn't call, and a Purple Heart in a drawer, and a roof that someone else broke. Behind every routine case is the possibility that what looks small from the bench is, to the person standing at the podium, the entire weight of their life. See that? Every time, without exception. If you are a person who watches this and works in a building like mine, hear this. Do not process people. See them. 8 seconds. A question. What are you carrying that you should not be carrying alone? If you are a person who watches this and is sitting somewhere with a worn manila envelope and a reason not to come, hear this. Come. Bring it. The door is open. And if it is not open, knock until it is, because the people inside that room work for you, not the other way around. And if you are a person who watches this and has spent any part of your life doing what that contractor did, targeting the old, the grieving, the isolated, the trusting, hear this most of all. This room is patient. This room is thorough. And this room has a very long memory. Court is in session.